Hey everybody, and welcome to this week's class. Today we're going to be talking about Fourth Amendment searches. Now, we'll get into the text of the Fourth Amendment in just a second, but I wanted to be clear about why we're going to differentiate between searches and seizures, and why we're going to pretty much ignore seizures. Searches are by far what people are concerned about the most. A seizure is when we actually take the property. A search is when we look for things. The reason we're not going to cover seizures this time is because this is by far a lot less than what people care about. From a purely academic standpoint, you can't really have one without the other, but we're going to focus on the search aspect because the seizure aspect is more legal and less what you're going to find videos on. So let's move on to the next slide. Here's the text of the amendment, and it reads, "The right of the people to be secure in..." The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Now, there's a lot to unpack there, but we're going to explore it in the context of the videos you all shared with me this week. So here's the first one, and I'm going to go ahead and get rid of my image so you guys can see it more clearly.
Suppose officers Jack and Jill are on patrol one night in a seedy and dangerous part of town. At around 1 a.m., Jack and Jill, from inside their patrol car, see Bruno standing alone at a street corner with his hands in his pockets. Jack pulls up alongside Bruno, and Jill leans out the passenger side window and calls to Bruno, asking to speak with him. The patrol car is clearly marked, and Jack and Jill are in uniform. At this point, has a seizure occurred? Answer: no. Now, some of you might argue that no one really feels free to leave when the police come up and ask to speak with them. That may be true, but even so, in a public place like a street corner, private people have every...
All right, and now we're going to go to the second video, and we'll talk about both of them together in a minute.
Earlier this year, social media erupted with outrage against the TSA after a video surfaced in which a young boy with sensory processing disorder was subjected to a thorough pat-down at the Dallas-Fort Worth International Airport. Aggressive searches such as these are conducted under the flawed pretext that they are necessary to keep passengers safe. But airports are not the only place people, including children, are pat down despite not being suspected of a crime. In December 2014, a student at Fremont High School in Utah noticed another student carrying a firearm. The teenager was taken into custody, police were called, and then every student was subjected to an invasive pat-down search as officers worked to confirm that no other weapon was present.
None of the students were allowed to leave until they were patted down and cleared by police.
One student interviewed by Libertas Institute said she was uncomfortable with the pat-down, which she called aggressive. She continued, "They were grabbing my private areas when I hadn't done anything wrong." This student is right. She was never suspected of having done anything wrong, and yet, along with every other child on campus that day, she and her belongings were searched. The Fourth Amendment to the U.S. Constitution is clear that individuals have the right to be secure against unreasonable searches and seizures, and touching the private parts of hundreds of innocent children is quite unreasonable. The Fourth Amendment further states that to perform such searches, warrants are necessary, and that a warrant requires probable cause and particularity, or in other words, individual suspicion of a person having violated the law. When you're at the TSA, you are not individually suspected of carrying a weapon. When these students were at school, they were not individually suspected of being armed. Without that suspicion, government employees are violating our rights by putting their hands on our bodies and searching our belongings. If the past couple of decades have taught us anything, it's that unsubstantiated fears too easily lead to the violation of our rights. This unfortunate trend has to stop, and we should begin here in Utah. For Libertas Institute, I'm Michelle Aiden.
So those were our two videos that were submitted. And before we dive into them, which I promise that's at the bottom of this outline, we'll get to them. But I want to go over the fundamentals of the Fourth Amendment first. And that's that first, people are free from unreasonable searches and seizures. And that term I've highlighted both in the text of the Constitution and here in the notes, in the outline, because it is such a fundamental thing to grasp. This is where most people miss the boat. The term unreasonable means that it's going to be different depending on the circumstances we're at. So first, a warrant is a legal document, and when a warrant issues, that means that the search is going to be reasonable so long as that warrant's properly issued. And we'll talk about what makes a warrant proper in just a minute, but let's skip over it first and say that if there's a warrant, it's probably reasonable. Second, there are tons of exceptions to the general rule that in order for you to be searched, there should be a warrant. Some are based on circumstances, such as exigent circumstances, search incident to arrest, or an inventory search. Some are based on location, like the open field doctrine, where they can't search the curtilage of your house, but if you have tons of fields or tons of property, they can search that. Plain view doctrine, where they can search something they can easily see, and the automobile exception, where they get to search your car. Warrants are required to be specific as to what should be searched, who should be searched, where the search should be conducted, and why the officers want it. Now let's take a minute to break down the video. In the first video, this is an example of a Terry stop. In Terry versus Ohio, the Supreme Court of the United States authorized a limited scope stop and frisks. In Terry, this was because officers observed a suspicious individual walking back and forth in front of a jewelry store in an area that was known to be dangerous. There were lots of robberies and stuff like that. Officers stopped this individual, patted him down, and found burglary tools on his person. The Supreme Court said that this sort of behavior is exactly what we want officers doing. So if there are clear and articulable facts to believe that criminal activity is afoot, then officers have an ability to stop and frisk people. While sort of a seizure and sort of a search, it really isn't. And because of that, they're subject to a lot lessened of an evidentiary standard. So with a search, they can, go into your belongings and check within your garments and stuff like that. With a Terry stop, they can only pat down the outermost layer of clothing to see if you've got some sort of weapon on you. Now, if they feel something that obviously is contraband but isn't a weapon, they can also remove that, because that gets into that plain field doctrine, which is one of the search exceptions. The second video centers all around what's reasonable. While absolutely correct, police officers can't just walk up and randomly start searching everybody. There's a little bit of a difference when it comes to schools and the TSA. So while this would not be tolerated in a normal circumstance, we have different expectations as to what is reasonable depending on where we are. In public schools, for example, there is a significantly decreased expectation of privacy, as administrators are sit in loco parentis. This means that they basically are the parents. The question is, can your parents search you for a gun? And the answer is absolutely yes. So can administrators. They still have some semblance of requirement for the Fourth Amendment, but it's significantly decreased. So saying that this was a massive violation of the Fourth Amendment, maybe it was, maybe it wasn't. It's going to depend entirely on the circumstances, but it's not as cut and dry as the video makes it seem. Similarly, at border crossings, and the TSA is treated as a border crossing, more invasive searches are absolutely permitted. This is, again, because this is an optional thing. You don't have to fly. You can drive across the country. You don't have to leave or enter the country. There's a decreased expectation to what is considered unreasonable there. And as such, yeah, they can absolutely pat you down, and they don't really need much provocation for that. Again, I'm not aware of the particular facts in the case that this lady is referring to, but I would like to point out that it's kind of telling to me that she's presenting this as from a very informative standpoint, saying, hey, the government is invading our civil liberties, and she's working for the company that took this person's statement, and presumably is advocating for better control of the Fourth Amendment. So now on to me completely geeking out and talking about this from an academic perspective. The fact of the matter is that the Fourth Amendment is constantly in flux. Like most of the amendments we talk about, we are going to see it give more protection and less protection depending on the current climate we're in. For example, about 20 years ago, we had the Patriot Act. Well, yeah, about 20 years ago, we had the Patriot Act. This significantly limited the protections afforded to you by the Fourth, Fifth, and Sixth Amendments. But now that's expired, and that sort of thing wouldn't be tolerated. Based on what's going on, we're going to either enforce things more strictly or more loosely. That's really a question for the Supreme Court, but it does have everyday implications. So is she right? Well, partially. This is probably not the best thing to have happened with the TSA and with this school, but it's hard to tell what the spirit of the Fourth Amendment would really protect. Because remember, at the end of the day, it all comes down to that term. You are to be secure in your basically stuff from unreasonable searches and seizures. Next class, we're going to cover the Fifth Amendment. You'll see in the Obsidian notes that I have put the link for you to upload your videos there. Some of you are having a difficult time uploading videos, and you've been sending in either a text file or a Microsoft Word document with a link to a YouTube video. If you can link to a YouTube video, that's perfectly fine with me. If you can download it, that's the gold standard, but you're not going to get any points off if you send me a video from YouTube. So if you have any questions, particularly about that final project, which is going to be due in about a month, a little bit less than a month, please feel free to give me a call or shoot me a message. And I look forward to seeing you all next week when we're going to talk about the Fifth Amendment. Thank you, and have a great evening. Goodbye.